I'm very sad that this course this part of the course is ending, but there is a good news that the director of the department renovate our agreement for the next semester. So there will be another course of international law. I will have to discuss with the university on the way it will be executed, in the sense that here's a continuation of what we are doing now, or do both something like this, repeat this course for new students, and do other matters for you that you already attended this course. We will see. Anyway, and I want to thank you a lot for your warm welcoming when I was being at the university. It was a real pleasure to teach in person. Actually, it's the way the teaching should be. And I hope for the next semester for some of you, if you follow the second part of the course, there will be the chance to see each other more frequently in person and to have more live lesson. Anyway, I'm very happy that anyway, if you are busy with other matters, at least 30 of you come to my lesson. It's really a great pleasure. So let's start with our last lesson. Today we speak about agreements between international organizations. This is the generic theme of the matter, of the subject. It will, to be more precise, should be agreement involving international organization, in which the international organization are one of the parties that sign a treaty. There are three types of agreements between international organization or involving international organization. The first one is the agreement in which the two parties are international organizations themselves. For example, a treaty between the European Union and the Organization of the African Countries, or the Organization of the South American country, or so on. Second type is the agreement in which one party is an international organization and the other is a single state that is already a member of the same organization. These are very particular type of treaties, is when something has to be negotiated regarding some specific matter, usually about economy or economical matter, or even matter regarding the military defense, if the organization is the international organization is a defensive military organization. Third type are the agreement in which one party is an international organization and the other is a single state that is not member of the same organization. For example, hopefully right now, for example, Ukraine is making several defensive agreements with several countries that are members of the NATO. Of course, in the future, probably it will join it, but in case maybe there could be the case of the NATO and Ukraine decide to sign a mutual agreement before Ukraine joining technically the organization. Usually, these type of treaties are used like a bridge for the accession of a single state new member to a multilateral to an international organization. The agreement between international organizations must not to be confused with the conclusion of the agreement between states through international organization. These are the cases in which the international organizations are not a proper party, but are simply a facilitator of the agreement. And that's why the name of the subject, agreement between international organizations, even if maybe it will be more correct to say agreements involving international organization. But of course, if we speak about agreement involving the international organization, we should include also this type of treaties in which the international organization is not a party, but simply a facilitator, it acts as a facilitator. The matter of the agreement between international organizations is disciplined by the Vienna Convention of 1986, which follow the same guidelines dictated by the Vienna Convention of 1969. We are briefly mentioning the Vienna Convention. The Vienna Convention of 1986 have as a main focus the treaties between international organizations, the agreement between international organizations. While the Vienna Convention of 1969 regards the drafting of the treaties in general, the rules about the treaties in general, and we already speak a lot about that. And today we will add some more details. From a technical point of view, each international we talk about the international organization side. From the technical point of view, each international organization statute should identify the organ that has a power to sign this type of treaty in its name. This is a kind of important, actually, not a kind, we can say it's very, very important. The statute of the organization also should identify the matters on which this power could be expressed. So we have two tracks. The statute should identify who has the power to sign, but also the matter in which it's possible to sign this agreement or treaties. Despite the fact that these two elements should be included in the statute, the statutory norms can be modified by the praxis if the latter is certain and consolidated. So if some matter are excluded by the statute, but for some reason the international organization decide to sign several treaties regarding a matter not included, and he do constantly, maybe with several different single countries, this is something that could be acceptable, but it's, of course, the praxis should be certain and, as I said, consolidated, so repeated over the time. Again, we can, as we have the rules regarding the statutory norms, let's say can modified by the praxis. Even the praxis can be, let's say, modified or not accepted or recognized as not correct. When this happens, this is happen if the international organization has an international jurisdictional body. In these cases, if the organization has this internal jurisdictional body, the changes in the regulation introduced by the praxis are subjected also to its judgment. So if the legal precedent of this the legal precedent of this judicial body should be taken in consideration concerning the power to sign these treaties. In other words, if the praxis changes the statutory norms, so we have several treaties signed by in a matter that is not included in the statutory norms itself, and the organization has an internal judicial body, this judicial body is free to decide about this change of practice and could be approved or not approved. And if these changes are not approved, this legal precedent should be kept in consideration before to proceed with proceed with a new signature according to the praxis. I explain myself better. The international organization signed a treaty with the state A, violating the norms. So, signing something that is outside the statutory norms. Then you do it with the state 2. Then with the state 3, we have what we can call a consolidated praxis. But if the organization has a judicial body, international body, internal body like a court, and this court say, sorry guys, the agreement with the state 3 cannot be signed because it's out of the norms of this organization, what's happened? The agreement 3 is cancelled. Although the other can be cancelled, for sure it's not possible to apply this consolidated praxis for the future with the state 4, 5, or 6. I hope that I've been clear. To make a clear example of a legal precedent created by an international jurisdictional body, we have to go back to 1994. In 1994, the Court of the European Community, note, at the time we didn't still have the European Union. We still have just the European Economic Community. The Court of the European Community cancelled the signature of a treaty between the community itself and the United States in the competitive law matter, because at the time the European Commission, who has signed this treaty, by statute didn't have the power to sign this type of treaty. This is a kind of concrete example. Now the European Commission has the full power to do it. The type of agreements between international organizations have very limited, when we have two international organizations, has a very limited relevancy. Such as in the case of treaties on exchanging information or other formal protocol. So it's something that is done for, let's say, courtesy or other, to facilitate some type of relation. The relevancy of this type of treaty is so limited that some experts even negate that this type of treaty has real judicial relevance. In regards to the agreement in which one party is the international organization and the other is a single state, member of the organization or not members of the same organization, there are not particular difference between them. Basically, the drafting of the treaties with a member state and the drafting of a treaty with a non-member state are very much alike. It's not something. There are no particular difference, and in addition, this treaty generally follow the same rules between the treaties between single states. So we have all the process that we already covered in the last during the last lesson, and we speak also during the lesson before. So we have all the phases. We have the negotiation, the signature, and so on, and ratification, and so on. Usually, nothing changes. Ineffectiveness of the treaties toward the third party states. As many times I have make a comparison between the international treaty and the commercial law contract or the civil law contracts. The treaties are just like a contract. Here we go again on this point. The treaties, just like the contracts in civil and commercial law, have effects and creates bonds only between the signing parties, the signing state, and not the third party represented by other states. So in a commercial contract, we have two subjects, one selling, one buying, and so on. And the effect usually are between these two parties. In the same way, when we have a treaty signed by two states, for example, Italy sign a treaty with France or with Algeria or Montenegro, to speak about some neighbor country that are not in the European Union. These treaties have not effect on the other state, on the relation with the other state. This is the general rule. The main exception to this rule is the case in which there is an implicit acceptance of the treaty by third parties. What it means? It means that this implicit acceptance do not imply the formal accession to the third party state to the treaty. It doesn't mean there could be some limited effects as a consequence of the treaty signed by two states for the third party, without the necessity of this third state to join the treaty. Simply because these effects are because in some way the third party is involved, is in some way involved by the practical effect. For example, we talk about later, more deeply later, the treaties on the riverine navigation. This usually involves all the states that have access to the river. So if are downstream or upstream, two parties that sign a treaty. To make an example, for example, you consider the River Rhine. France and Germany do a treaty, sign a treaty regarding the navigation of on the river Rhine. We have Switzerland, who is upstream, and Holland or Netherlands that is downstream, and they could be also could have effect on this agreement. They can be, this effect can be created if, for in this case, Switzerland or Netherlands do not refuse this act, don't openly refuse. But this doesn't. This is a case of implicit acceptance. But this doesn't mean that that they need to be part of the agreement between France and Germany. This in another exception of the effect of a treaty between two states that toward a third party state is the case in which the treaty is signed by the states parties in favor of one or more third parties. This is, for example, in some cases, this is something that is not type of treaties that is not used so much anymore. This was in the past century something that was quite not quite common, but not uncommon. For example, two big powers sign a treaty to guarantee the freedom or the independence of a smaller state because they have a kind of interest in his independence, in this situation, maybe because the smaller state was a buffer, represent a buffer zone. It could be, or they have a strong minority of this of kind of ethnicity connected with these two powers. One example was a treaty signed in 1845 to guarantee the independence of two duchdom in northern Germany toward Denmark. These two dukedom, they were they were partially Danish-speaking people, they were partially German-speaking people, and there was an agreement, a treaty between Prussia and Austria to guarantee their independence as a part of the Rhine Confederation. At the time, Prussia was rising as the powerful future nation of the German-speaking area. Austria was a leading, the Austrian Empire was the leading power of the German Confederation, the Confederation of the German Confederation. So they have an interest that these two dukedoms that were independent was not absorbed by Denmark. And when these two, they were Schleswig-Holstein, this is the name of the two dukedom. And when Denmark tried to annex these two small realms, Prussia and Austria intervened, and there was a war between Austria and Prussia against Denmark. By the way, these two small kingdoms were connected with Denmark because even if they were independent, the legitimate rule was the King of Denmark. An example of, as I said before, an example of treaties in favor of one or more third parties are the riverine treaties. These treaties guarantee the freedom, usually guarantee the freedom of navigation on rivers, not only for the signing state, but to all the state to have access to the river navigation. Before I mention a treaty for the freedom of navigation on the Rhine, but for example, similar situation and more complicated situation can be for the Danube. The Danube starts in Switzerland, briefly border Germany, it passed through Austria, it passed through Croatia, Dutch Slovenia, passed through Serbia, and it ended up in Romania. So you have a lot of countries, and so this type of treaties can be more important. Or we have the same type of treaties in Africa where there are rivers that go through five or six countries. The advantages granted to these treaties to third-party states, they have are particular because they can always be revoked until the third-party state become a proper party of the treaty. So two countries sign a treaty or multiple, there can be a multilateral agreement. This indirectly, this treaty gives some guarantees and rights to other countries, but this right can be revoked if at any time if this country, this third-party country, do not become a part of this treaty. The position of this third-party state and the effect of the treaties for a third-party state are mentioned in the Vienna Convention of 1969. The Vienna Convention dedicated 3 articles to the effects of the treaties on a treaty on the third-party states. The effects of the treaty on the party state are disciplined by the article from 34 to 37. The Vienna Convention, with this article, stated the necessity of an accession of the third-party state to the treaty to to grant both right and obligation to the latter toward the signer state. The convention affirmed in particular the necessity of consent of the third party state toward both right and obligation. So they cannot, the third party cannot get any right or be burdened by any obligation if they don't consent about that. Second point, the will of the contracting parties to create an obligation for the third parties and there is the necessity of the will of the contracting party to create an obligation toward for the third party, and there is also a necessity of the of a written consent of the latter. So we have something. We have basically for in case an obligation, we should have a written consent of the third party state who receive this on which this burden, this obligation is placed on which. Another important affirmation of the by the Vienna Convention is a presumption of the consent by third party in case of assignment of right. So I don't need to have the consent of the written consent of the third party to receive these rights, but at least they have a situation in which I can assume that the third party state agrees on to receive this right. Another last point affirmed by the convention is the revocability at any time of the right assigned to the third party unless the contracting parties agreed on the opposite. So before we say that if the right given to the third parties can be in any case, in any time revocated until the third party state became a proper party of the treaty and join this treaty. Here we say something that little more. The Vienna Convention on this matter say that the right given cannot can always be revocated, but unless the original party of the treaty do not dispose in the opposite way, agreed on the opposite way. Basically say, yes, you cannot, you can revoke anytime, but if you state in written in the treaty that the right given to the third party who probably accepted them because they don't make any, don't give any sign that they are against the assignment of this right. If you write in the treaty that this right are not revocable, this right became permanent. You cannot revoke them anytime, even if the third party do not become part of the treaty, proper part of the treaty. Other element as an important element of the talking about treaty, the incompatibility between the rules of the treaties. We have why this element is very important, because in the life of the state could be several event period and there could happen different events that influence their politics, their history, and these events can be the signature of different treaties regarding the same matter, different during the history with different other states. You imagine that you have a lot of neighbor where in apartment you live and you sign agreement time by time with many of them with different matter. So it could happen that states sign more treaties during the time with different conditions, with different parties, or even with the same party. It's happened quite often that the treaty between two states on a specific matter is replaced by another signed subsequently. It's not something that is not an uncommon practice, because the treaties are subjected to the time. So if the general politics condition and the international situation change, even the treaty can need an update or a change. Of course, there is one treaty, I tell you a curiosity. The oldest treaty signed, we're still in effect right now. It's a treaty between the kingdom of Portugal and the kingdom of England. It was signed in the mid of the 14th century. It was a military alliance, and it never be cancelled. It's still valid, and is still honored. It's still been honored through the century. When Portugal was invaded by Napoleon, basically more than 450 years after this treaty was signed, the British sent an army to help Portugal. And during during the First World War, the Germans invaded Portugal. Of course, the British were already at war with Germany, but they sent troops to defend the Portuguese colony, and the Portuguese sent expedition court on the Western Front. At the beginning of the Second World War, of course, Kingdom of England doesn't exist anymore. There was Great Britain, and the Portugal became a republic, but the republic was still bounded from this treaty, and the republic, the government of the Republic of Portugal at the time, Portugal was a kind of dictatorship ruled by a gentleman named Salazar. Mr. Salazar and his government asked England if they want Portugal to join the war against Germany. So the Portuguese was ready to honor this treaty after basically 600 years. And the United Kingdom government, Mr. Churchill, declined the offer, saying that for them was more, let's say, important, more useful to have the Portugal neutral than at war. So change. So this is a rare case because in many, during the time, the treaties, many treaties are updated and changed. What happened if we have a treaty on the same matter between the same state? Simply, the new treaty replaced the old one, and everything go on in the same way. However, it can also happen that the state sign a treaty with another, but subsequently signs another with the third state that regulates the same matter according to different rules. So I sign, I make an example that I remember. The treaty signed between United States and Great Britain that I think was beginning of last century, 1905, 1906. United States signed a treaty with Britain establishing the tariff of the vessel who crossed the Panama Channel. Few years later, they signed also another treaty with Panama, with the Panama state that exempt some of some ships of a certain size from the payment of this fee for crossing the channel. And this creates a kind of unusual situation because we have a treaty with one nation that obliged to pay a fee to crossing the channel, whatever was the size of these ships, and the sign treaty with another nation, with another state, which have his ship we exempted to pay the fee if the treaties, if the ships were smaller than a certain size. So two different, it's the same matter treated in the same way. Another case of different of incompatibility between rules could happen if in a multilateral treaty is signed between several states, and later some of these states sign an agreement that provide for different rules in mutual relations. What it means, there is a general agreement between several states of the same area to say that they agree in a certain way to manage a certain matter. For example, the navigation on a lake that is touched by everybody, or a certain sea or certain area. I use a lot the sea travel, travel as an example, because this is something quite common in this field. Later, two of these states who has signed this multilateral agreement make an agreement between themselves dictating new rules that are different from the multilateral agreement. In this case, there is a problem of managing the incompatibility of rules between the various treaties. How we can solve this problem? So two treaties, same matter, different rules. According to the dominant doctrine and the judicial precedents, because there have been also several arbitration on this matter, several legal precedents by several different courts, international courts, the problem should be solved combining the principle of succession of treaties and the ineffectiveness of the treaties toward third parties. So, what means? We have two principles. We have the principle of succession. So, I sign a treaty, then I sign another treaty on the same matter. The second one is the one who is valid. The other principle is the ineffectiveness toward the third parties. I sign with him. I don't sign, you are not involved, you are not touched from this matter, by this matter. What is the result of the application of this principle? We have two, let's say, kind of rules from the combination of this principle. The states that participate in both treaties will have to respect the treaty stipulated subsequently in the application of the principle of the treaties, or principle of succession of the treaty. So we have two treaties that dictate different rules. We have some rules between me and you, some rules in the dictated by a multilateral treaty in which both of us are signer. Who are the one? Which are the what are the rules to be applied? The newest. Doesn't matter is between me and you only or us inside the community. The newest are the one to be applied. Second point, based on the ineffectiveness of the treaties toward the third parties, the states that have stipulated only one of the treaties remain bound to what is indicated in the agreement, given the rules of ineffectiveness of the treaty toward the third parties. So, first case, we have two states that are involved in both the treaties. In the second case, in which is I'm a member of a multilateral treaties, I have agreed to manage the matter in this way, and then I do an agreement with another state that is not part of this multilateral treaty, and considering that this party is not part of the other organization, toward this third party, I should apply only the regulation that I agreed with it, not the general rules established with the multilateral treaty, even if the matter is the same. This gives us a rule, but in some way it creates also a problem, because consider that this last type of situation, the contracting states of two treaties will be obliged to behave in two contrary ways, and therefore they have to choose one, respecting only one of the two mentioned treaties. This state will have will still incur in an international offense against the state that signed the other treaty. Different word. I decide how to manage, I sign a treaty, how to multilateral treaty, how we manage the navigation on the Adriatic Sea with Italy. I'm Italy. I sign with Slovenia, Croatia, Montenegro, Albania, Greece, Albania, and let's take out Albania. We decide how to manage the navigation inside the region. Albania is not part of this treaty. I sign a treaty with Albania who have different rules from the rules that I set with all the others. I have to choose. Technically speaking, towards Albania, I should apply only the rules of the treaty with Albania because it's not part of the other. But considering that these rules are different, I'll make I choosing to deal the matter with Albania in the same way stated in the treaty, and not like I agree with all the other, I make an international offense towards the other. Same way, if I decide not to apply the principle of the third parties, but I say, okay, I will treat all the countries in the same way, following the agreement I had with all the other countries, and I treat Albania as I treat all the other the state member of the treaty, I'll make an international offense against Albania. So it's a right kind of very tricky matter, because you are always between fire and ice. A notable exception to these rules is the set of rules is the Article 103 of the United Nations Charter, which consider the obligation deriving from the Charter to prevail over those or any other international agreement. This is something that was very intelligent, very wise from the drafter of the United Nations Charter. So they already stated that if you sign the United Nations Charter, the United Nations Charter will prevail over any other treaties. Actually, this is something that the provision that is not needed anymore, because more or less all the countries are part of the United Nations. So, and everybody accepted these rules. Again, we go back on the Vienna Convention of 1969, because even the Vienna Convention 1969 dictated rules on the incompatibility between the treaties. The Vienna Convention in 1969 deals with the problem with the incompatibility between provision of treaties in the article number 30 and 41. So we have two different articles. The Article 41 is rather ambiguous as a rather ambiguous formulation of the problem, because it seems to accept the thesis of the invalidity of the subsequent agreement in the event of conflict between rules. Basically, that the second one is not the second one is not valid if you already agreed to deal the matter in one way. Let's read. I read the text of the article. The article has two comma. Comma one: two or more parties to a mutual treaty may conclude an agreement to modify the treaties as between themselves alone, if so, two parties of multilateral treaty. If the possibility of such modification is provided for by the treaty. Two, the modification in question is not prohibited by the treaty, and point one, does not affect the enjoyment by the other parties of their right under the treaty or the performance of their obligation. Two, does not relate to a provision, derogation from which is incompatible with the effective execution of the object and the purpose of the treaty as a whole. So, this seems to say that if you're already part of a multilateral agreement, you cannot sign a different agreement between. It's not possible. If two parties are, two states are part of multilateral agreement, they cannot sign a second agreement between themselves with different conditions, same matter. Or they can do it, but they have to respect this point. So the first treaty should allow the modification of the rules. This modification is not prohibited. It did not affect the other parties. It is not connected to a provision that is not that it cannot be derogated. Second comma, unless in a case falling under paragraph 1, point A, that means the possibility of such modification is prohibited by the treaty. The treaty otherwise provides the parties in question shall notify the other parties of their intention to conclude the agreement and the modification of the treaty for which it provides. So, the modification has been, according to com 1.1.8, the possibility to except the case in which the modification is allowed by first treaty, you had to notify to the other parties your intention to modify the rules between you and another state who is already signed the multilateral treaty. Assuming the two or more parties to a multilateral treaty cannot conclude a treaty that aims to modify the first one when the modification is prohibited by the mentioned treaty by the mentioned multilateral treaty. 2, it creates a prejudice against the other contracting parties. 3, it is incompatible with the realization of the object and the purpose of the multilateral treaty itself. These are the 3, let's say, gold rules. This provision is applied even if the new bilateral treaty limited only their relations. Only if they discuss about this relation. Despite the content of the Article 41, that is quite articulated, the situation is not completely clear, because the Convention of Vienna itself do not list the violation of the mentioned article among the causes of invalidation of the treaty. So what happened? Let's say that the Article 41 dictates can extract these 3 gold rules, but the Vienna Convention doesn't state that because you violate the Article 41 drafting a treaty, a bilateral treaty, this treaty is automatically invalid. Again, is that the Article 30 that we already know, we have said that we have 2 articles, 41 and 30, introduce the concept of compatibility and subordination clause, stating that when a treaty specifies that is subordinate to a previous or subsequent treaty, the provision of the latter prevail. Fundamental, basic what they say is we sign we sign a treaty. In this treaty, we insert a clause that provides the fact that provides that we insert an article that states that the rules of this treaty are subordinated and must be compatible and are subordinated in any case to the clause of a previous signed treaty. The first one prevails. Going back to our example, we have 2 states, part of the same multilateral agreement. They later sign a treaty between themselves, changing something smaller or bigger in the way in their relation of the same matter, but they can include a clause saying if this treaty provoke an incompatibility, they have an incompatibility problem with the main multinational, with the multilateral treaty that we both have signed before, the multilateral treaty clause will prevail. The inclusion of a subordination clause to a previous treaty in the text of the new treaty should limit the cases of incompatibility of the clause, preventing the value of the previously treaty signed. In this way, the Vienna Convention suggested a kind of technical remedy. Basically, with the Article 30 and the concept of subordination, of the subordination clause, we have the effort to mitigate the case of incompatibility. of the treaties. We cannot be 100% sure that we are able to avoid them. Other interesting feature of the treaties is the reservation condition. What is a reservation condition? The reservation condition is a typical institution of the multilateral treaties. This condition is a will declaration that states make about certain clauses signed of a signed treaty. Adding a reserve condition to a treaty, the signer can decide not accepting some clause of the treaty, accept some clauses with some modification, or accept some clauses according to a certain interpretation expressed through the so-called interpretive declaration. So, I join a multilateral treaty as a state, but there are some clauses that I don't like, I don't agree totally, it can be against my interest or even my constitutional principle or so on. What I can do? I insert this reserve condition clause saying, I accept the treaty, but I not accept this clause. I accept the treaty, but this clause should be toward me, involving me, is modified in this way. I accept the treaty, but this clause should be interpreted as for the following interpretative declaration. The interpretative declaration of not accepting one or more norms of a treaty, except in a certain meaning, makes other interpretation of the norm non-proposable to the declaring state. So I declare that I don't accept this interpretation of the norm. This is not, this interpretation of the norm is not acceptable for me. As I say, the reservation condition is another remedy to try to limit the case of incompatibility of the norms from different treaties. As a consequence of the reservation, the agreement between the state that outlawed it and the other contracting state is formed only for the party not covered by the reservation, while between the other state, the treaty remains fully applicable. So I express reserve. The treaty is on this clause. This clause is valid toward any other parties of the treaty. Any other signing state is not valid, just for me. The reservation has the aim of allowing the widest possible participation in multilateral treaties and makes no sense in bilateral treaties. Why? And this is very kind of obvious. Sorry. Because in the bilateral treaty, if the party doesn't want to make certain commitments, can directly propose the deletion from the text of the clause on which there is a difference of opinion. It's obvious. In a bilateral treaty, sorry again, if I don't want a clause, I simply say during the negotiation phase to my plenipotentiary, delete it, cancel, change it, do whatever you want, I will not sign. With the multilateral, is a kind of difference because you have to make a conciliation between several different points of view. The reservation has been used in the international law for a long time and has undergone quite a few transformations. We have a long, let's say, history of changes in the reservation condition, in how the reservation condition should be insert or meant. First is the first step is the reservation, how it's been according to the international classic, to the classic international law. According to the classic international law, the possibility of placing the placing reservation have to be or had to have already been agreed in the negotiation phase, and the reservation itself had to appear in the text prepared by the plenipotentiaries. At this point, the state could choose whether ratify or not. Formulating the reservation not foreseen in the text prevented the formation of the consensus and led to exclusion of the state from the list of the contracting parties. So, for the classical international law, the reservation has to be submitted to the other parties during the negotiation phase and not later. It would be if it will be presented and when it's present, it is submitted to the other parties during the negotiation phase. Later, there can be a ratification or not, because if you remember, there is a phase of negotiation to the plenipotentiary. There is a signature, then there is a ratification by the government of the state. In this case, what they say, you insert, you expose your concern during the negotiation, you can sign it with you can sign the treaty, including the reservation condition. Later, your government can decide to accept this reservation or not, ratify or not. But if you express the reservation at the moment of the signature or or at the moment of the ratification, if you do this, this automatically exclude you from the treaty. So you cannot go and express your reservation at the time of signature or at the time of the, even worse, at the time of the ratification. The reservation accord is, this is a classical traditional interpretation. The reservation according to today's international law. The modern concept of the reservation is based on an opinion of the International Court of Justice of 1951 in response to a request of the United Nations General Assembly regarding the possibility to placing reservation on the Genocide Convention, which did not include such a clause. So the International Court of Justice was to the General Assembly submitted to the International Court of Justice this question. It was possible to accept, to place reservation on the Genocide Convention that in the text do not provide. The court replied, a reservation could be formulated at the time of the ratification, even if the option was not provided by the convention, if it is compatible with the object and the purpose of the treaty. In other words, according to the court, the reservation is valid as long as it doesn't distort the meaning of the treaty or affects its fundamental elements. This important statement was mitigated by the court itself, which also stated, another state, signing state, may, however, dispute the reservation and its compatibility with the spirit of the treaty. If no agreement is reached on this point, the treaty does not exist between disputing state and the reservation state. Coming back, I make a classic point of view. I can make a reservation, but I have to do it during the negotiation phase. Otherwise, it's not acceptable. And you are excluded automatically from the signer. The position of the International Court of Justice. Yes, the reservation is acceptable anytime unless it is compatible with the object of the treaty and doesn't change the meaning of the treaty. But if one of the signers do not agree on this reserve and no agreement is found between the disputing states and the reservation state, the disputing state is the one who don't, or the state who does not agree on the reserve, and the reservation state is the one who proposed the reserve, the treaty doesn't exist between these two parties. Third point of view regarding the reservation. After the court, the legal opinion of the International Court of Justice, there have been the Vienna Convention of 1969. How is the reservation according to the Vienna Convention 1969? The Vienna Convention dedicated 3 articles, 19, 20, and 21, to the reservation condition. This their content is largely based on the previous Court of Justice legal opinion. The Article 9 states that a reservation can always be formulated provided that it is not expressly excluded by the treaty and provided it is not incompatible with the object and the purpose of the same. So here what we add, the fact that the reservation should not be expressly excluded. And second, but we are in the same way, is not incompatible with the object of the treaty. More or less, we are on the same point of the Court of Justice opinion, legal opinion. Article 20. This article states that when the reservation is not foreseen in the text of the treaty, can be contested by another contracting party, but if the contestation is not expressly within 12 months of the negotiation of the reservation to the contractor, the reservation is considered as accepted. Court of Justice said, in case of a reservation clause is contested, they say, Court of Justice says, the parties have to find an agreement. If they don't find an agreement, the treaty is not valid between the two parties. Article 20 had a limit, because it states, it gives the deadline of 12 months from for notified from the of 12 months to notify the issue regarding the potential issue regarding the reservation condition. Basically, I do not agree on the reservation. I had 12 months since I received news of this, probably at the time of the signature or the ratification. I have 12 months to notify my dissent to the other contractors, to all the other parties of the multilateral treaty. If I don't do it, it's implicit that I agree and the reservation is considered as accepted. Article 21, the last one. This article states that the objection to a reservation does not prevent it from exerting its effect in the relation between the making state and the objecting state, unless the latter has expressed a clear and manifest intention to prevent the treaty from coming into force in the relation between the two states. This means that the object of the state, if it wants to prevent the reservation from taking effect, must specify this. So this is another limit. So not only I have 12 months to make a notification of my dissent, but I have to state clearly that I don't want to accept the reservation condition proposed by another contracting state. So if I don't want it to have effect, I have to not only I have to express clearly my dissent, and I have to do it within 12 months. We can conclude that the two principles emerge from the Vienna Convention's article. An objective principle based on the incompatibility or compatibility with the matters of the text of the treaty, and the subjective principle based on the lack or the presence of complaints of the signer state. So, the first is expressed by article, is expressed by article 19. The subjective principle is based on the article 20 and 21. So limit and clear expression of dissent. What happened in case of a conflict between this principle? The objective principle is considered as prevalent. Following the Convention of Vienna, there were also another approach, another step given by the praxis, according to the legal precedents after the Vienna Convention. In the event of an inadmissible reservation being formulated, excluded from the text, text excluded from the text, contrary or to the object or the purpose of the treaty, whatever, the formulating state is not excluded from the treaty, but only the reservation is invalid and must be considered as not having been made. So, after the Vienna Convention, there were some legal precedent according which the if the reservation has been considered as not admissible, is considered inadmissible, whatever the reservation is not valid, and you could see, and the state that expressed it is bounded just like the other. Is not excluded from the treaty, but is considered bounded by the treaty. What is also this theory has a limit, because it's doubtful that this legal precedent can be applied outside the human rights field, due to the fact that they are produced by the European Court of the Human Rights. So a court that specifically focused on the human rights field. So for sure, if the treaties regard the human rights, if the reservation is not admissible, you are bounded. It's doubtful that if the reservation is not admissible, as a consequence, you are excluded from the treaty. Last point on the introduction of the reservation condition. Technically speaking, all the constitutional system should include a norm that designate the state authority with the power to decide regarding the inclusion of a reservation clause or in the treaty. You consider that you have in any legal system, you have the executive power, you have the legislative power. When we sign a treaty, we have an authority that decide, but there's need also ratification that usually are the legislative, the one is a combine of the both the executive and legislative. So both of the part of these authorities are involved in the creation of the treaty, the signature and the ratification of the treaty. In the same way, both one of them according the constitutional system, what is stated in the constitutional system, are involved in the creation or approval of the reservation condition, because it's like a clause, because it changed substantially the content of a treaty. Technically speaking, the best practice should be a sharing of this power, the power of decide about the inclusion of the reservation between the government representing the executive power and the parliament representing the legislative power, and the joint exercise of it. From the international point of view, it doesn't matter the constitutional setting of power of each country regarding the expression of a reservation on a treaty, exactly like the ratification or signature of a treaty. What is important at the international level is the external expression of will, while the potential abuse of a power, is strictly an internal matter, totally irrelevant in relation with the other state. In the international, from an international point of view, what is important is what the single state show on the international stage. So if usually this expression of will is given by the government because it's the leading figure and they have the executive power. So if the government has no power to do this, expression of will, or previously the government has not previously agreed on this expression of will with the legislative power, it doesn't matter for the international community. What is important is what is shown to the other. Therefore, a reservation illegitimately expressed or not expressed in a treaty will be valid or not considered valid by other state until a different external statement by the government. So I can express or not express, because it can be a reverse case. I can have a reservation condition not decided by the parliament, but not expressed by the government, I can have a reservation condition not decided by the parliament, but not agreed by the parliament and expressed by the government. Both cases. In both cases, what is important? What the government say to the other. The internal matter doesn't count. And the situation created by the expression of the reservation condition is valid until I have a new and a different external statement by the government. Okay. For today, for me, it will be all. I wouldn't steal to you any more time. I hope that also this lesson could be interesting, and I wish you the best for all of you. To all of you.
Thank you very much.
You're welcome.
Thank you.
Buona giornata.
Grazie.
Thank you for your contribution to our university and for providing all of this theoretical material. Thank you for sharing us your experience. I'm sure that all of the students are excited about the course of lectures with you. So we look forward for further meetings. Grazie per la vostra lezioni.
Thank you very much, and I look forward for it for other meetings, other lesson too.
Okay, thank you so much, Mr. Fabrizio. We will welcome you next year.
Okay.
Yeah, thank you. Bye.
Bye bye.